Okay, class, today we're going to be talking about Chapter 5, and Chapter 5 deals with civil liberties, or civil rights, I'm sorry, and there is a distinct difference between civil rights and civil liberties. When we talk about civil liberties, we're talking about those rights that are protected under the Bill of Rights, and when we talk about civil rights, we're talking about the equal treatment of individuals by the government and by the private sector, regardless of race, sex, religion, etc., etc. Now, in life, in every society, one of the ways we relate to people and understand people is that we as human beings apply labels to people, and we sort of put people in categories so that we can better understand them. We have cliches that say things like birds of a feather flock together, um, uh, which just highlights our tendency as human beings to categorize people, whether it be by the color of their skin or the language that they speak or the food that they eat or the music that they listen to or the college that they went to. We classify people by a myriad of descriptors, but we tend to cluster those people in groups. It helps us to understand, helps them to put that person and those people in perspectives, those members of that group. The question is can we have a society, can we have a government that treats people equally without regard to any of those labels that we've applied to them? Now, those labels, again, they may be important for our understanding intellectually or relating to sociologically, but can Lady Justice be blind? Can those Bill of Rights be applied absolutely, regardless of what label, sexual preference, religion, etc., etc.? Can it be applied equally and consistently? Our founding documents, the Declaration of Independence and our Constitution, which we've have started talking about, and we've already talked about the Bill of Rights, they contain some very high and lofty goals. But as we see, as we study the Constitution and we study American history, that there are times in our history we have failed to live up to those really lofty goals. So one of the ways that we attempted to try to make sure that the government saw or treated each individual equally is through the 14th Amendment. Now, what you have to understand, and one of the reasons that the 14th Amendment was needed is that prior to the 14th Amendment, number one, the Bill of Rights only applied to actions by the federal government. Okay, so the right to keep and bear arms that's protected by the Second Amendment really only gave guidance to the federal government. That right could have, without violating the Constitution of the U.S., limited individuals' rights to own firearms. Number two is that prior to the ratification of the 14th Amendment in 1868, the Constitution really didn't define who was a citizen. So the 14th Amendment for the first time does two things. It applies the Bill of Rights and the Constitution to actions by the state. And number two is it defines citizenship. Okay, now this is a response, and if you remember from American history, 1868, where the United States is in the middle of Reconstruction. We're trying to recover from war. Southern states are still pulling against the idea of equality. They are finding loopholes in the Constitution that continues to allow them to disenfranchise those former slaves. And so the 14th and 15th Amendments is really an attempt to bring southern states into control under the Constitution. So the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law. And we've heard that phrase before. Nor, and here is the Equal Protection Clause, nor deny to any person within its jurisdiction equal protection of the laws. So as you read your textbook, you're going to be reading about some very specific issues that we have faced. For instance, in regards to segregation, voting rights, rights for women to vote, rights for blacks to vote, so forth and so on. And so I'm not going to take this video and spend time talking about every one of those issues. I expect you to read and understand those issues. But what I'm going to focus on for just the few moments are the three tests that the Supreme Court uses. Now I say tests, you could use the word standard. The three standards that the Supreme Court uses when looking at any law or policy to determine whether or not it is discriminatory. All right, so the 14th Amendment doesn't require the government to treat all groups or people the same regardless of the circumstances. The Supreme Court has ruled that if the government can prove what is reasonably related to government interest, so if the law is reasonably related to government interest, the court has allowed those laws to stand. For instance, the federal drinking age of 21. Okay, that's the epitome of age discrimination. No one under the age of 21 can lawfully possess or consume alcohol in the United States. Okay, so the Supreme Court allows that law because the federal government is able to prove that there is a reasonable basis, that there is a direct relationship between the increase and decrease of alcohol-related fatalities on the road and age of the person consuming the alcohol. In other words, by raising the minimum age required to drink alcohol, the federal government can at the same time, in the interest of the public, reduce the number of casualties and injuries due to alcohol-related accidents. So there are three tests that the Supreme Court uses. Number one is strict scrutiny. Strict scrutiny means that the government has to show that the challenge classification serves a compelling state interest and that the classification is necessary to serve that interest. So if the classification is based on national origin, race, religion, alienage, those are all questions that if the classification has to do with those four things, the court says they're going to look at that with strict scrutiny, meaning there's a possibility that the court will look at the action of the government and say, yes, that law is okay, but the government has to prove that there is a reasonable basis for that law. Number two is the suspect category. the suspect category. Under the suspect category, the Supreme Court assumes that it's unconstitutional in the absence of overwhelming evidence. All right. So before they hear anything else, when they sit down to hear the facts of the case, the idea that the Supreme Court is going to have, if it has anything to do with denial or dilution of vote, interstate migration, access to courts, or other fundamental rights. If the law or policy addresses any of those four things, the Supreme Court is going to assume that that law or policy is unconstitutional unless there is overwhelming evidence that it's vital to the operation of the government. Third is the intermediate scrutiny. Under intermediate scrutiny, the government must show that the challenged classification serves an important state interest and that the classification is at least substantially related to serving that interest. So, any categories involving, for instance, gender, is an intermediate scrutiny issue. So, in your discussion board for week number 5, for chapter number 5, the question is about the Selective Service Act that requires males to register for the draft when they reach their 18th birthday, but exempts females from registering for the draft. So females do not, at this point in time, have to register for the draft. Today, women can serve in any role they choose in the military, including combat roles. Up to just a couple years ago, women could not serve in direct combat roles. That rule no longer exists. So my question for the discussion board is, should the law be changed? Should the Selective Service Act be changed to compel females to register for the draft? As always, explain why or why not. So when you start thinking about your answer, and you start formulating your response, think about intermediate scrutiny. And can you prove that not having females or having females to register for the draft, it serves a compelling, substantial interest of the state? By the way, simply throwing out an opinion about why women should not, or should is not going to be good enough. You need to support your opinion with academic sources, okay? Laws, examples that can be referenced, so forth and so on. I said 3 categories. There's actually 4. The 4th category is reasonable scrutiny. Reasonable scrutiny is the minimum scrutiny that the Supreme Court uses. And in reasonable scrutiny cases, the government need only show that the challenged classification is rationally related to a legitimate state interest. So it's a no suspect category, and that means that it's assumed constitutional, as opposed to the other categories assuming unconstitutional. Assumed constitutional unless no sound rationale for the law can be provided. And a good case in that is, and some of you may have watched the recent movie about Loving. It's based on a real case, Loving versus Virginia, 1967, where a white man and a black woman, Richard Loving and Mildred Jeter, who lived in Virginia, and they went to Washington, D.C., and they were married. And they went back to Virginia where they lived, and Virginia had a state law that made biracial marriages or interracial marriages illegal. Both were arrested and charged under that law, and Virginia Virginia argued in support of their case by saying that the law applied equally both to whites and blacks. The court found that the state of Virginia could not prove that the law had any validity at all. There was no sound rationale for the law as to how it helped the state, and so the court said it didn't do anything but support invidious racial discrimination, and the court struck that down. Please watch the videos that have been provided. The video, the I Have a Dream speech by Martin Luther King, still one of the most powerful speeches, in my opinion, that is in American history. Always, if you have any questions or I can help you in any way, whether it be with our subject that we're studying or whether it be something else, your career, a problem with Carl Albert, anything you might need, don't hesitate to give me an email or even call me here at my office. My number is 918-647-1454. Again, if you email me on my Carl Albert, not the class email, but my Carl Albert email, make sure that you identify yourself by name and your class by your class number, and as well as the section number. That way I don't have to try to look and figure out where you're at, so that I can reply to you. I will get back with you as soon as I can. Getting a hold of me, the best way to get a hold of me is probably an email. It'll come right to my phone and I'll get to you as soon as I can. Again, glad you're in class. If there's anything I can do to help you, please let me know, and I'll see you next week.